Hello, and welcome to A History of Mediation Part 1, or A Funny Thing Happened on the Way to My Conflict. In this video, we will explore some basic aspects of dispute resolution and mediation. We will take a short look at the alternative dispute resolution continuum, what mediation is, what mediators do, and the typical types of mediation. Hopefully, this will give you a little better understanding on the very complex topic of dispute resolution. There are 5 major types of dispute resolution, ranging from negotiation to litigation. It might be helpful to understand alternative dispute resolution processes by visualizing it as a line or a continuum where each of the various aspects fall and how they relate to one another. Noting how they can be ranked in the amount of time and resources needed to use them, how formal the process, the amount of control each party has, and their ability to generate their own options. We should note, however, each type of dispute resolution is not just a point on the continuum, but an area which encompasses a variety of modification or other similar processes. Negotiation. Negotiation is where parties discuss options without any outside intervention. This is just two people talking who can choose any lawful option they want. The best example is buying a used car. As long as the buyer and the seller agree, no one else is involved. They can agree on any price they want, from free to $1 billion to a Tootsie Roll. Litigation. Litigation is a formal process where a judge or a jury decides a dispute based on evidence presented by advocates, in most cases an attorney. It is binding and enforceable by law. Courts can award property, like an engagement ring, make a monetary award, like the value of an item or service, or force action, such as community service. Facilitation. Facilitation is where an outside person aids the parties in reaching a solution, often to be chosen from an existing list of potential options. Many professional consultants fit into this category, including wedding planners, strategic planners, and interior designers. Arbitration. Arbitration is where a selected neutral party decides a dispute based on evidence presented by the parties or their advocates. It is binding and enforceable by law. Arbitrators are empowered by being selected and by relevant legislation rather than by the justice system. They can only make a monetary award. Mediation. Mediation is where parties in conflict work to create a solution while a neutral person controls the process. It is the mediator's process, but the parties retain decision-making authority. It is the party's decision. As mentioned before, there are a variety of processes. Some of them blend processes together. These blended tools include facilitated conversations, neutral evaluation, non-binding arbitration, and coached communication. Remember, dispute resolution processes vary from state to state. You should consult with your local justice system on how these processes are used in your area. Earlier, we spoke of how mediation was a process wherein parties in conflict work with a mediator to help them to create solutions to their issues. The process of mediation is held up by 5 pillars, which help to ensure the integrity of the process. These pillars are: first, mediation is a confidential process. Any information the participants share during the mediation process will be handled responsibly and professionally, and will only ever be disclosed under very specific circumstances made clear to the parties. Next, it is a voluntary process. Participants make all their decisions without coercion or force, especially whether or not to participate in mediation at all. Any person may stop a mediation at any time. Mediation is a self-determining and empowering process. People in mediation are viewed as the experts on their own lives. All their decisions are respected. Mediation is an impartial process. A mediator will never give the impression of favoring one party over the other, and must be aware of their own cultural and personal biases at all times. Lastly, mediation is a safe process. The mediator is responsible for ensuring that the process is never used to attack, disparage, intimidate, threaten, or otherwise harm any party. When all 5 pillars are in place, mediation ensures a resolution process where everyone involved can find solutions which meet everyone's needs.
Your choice is simple. Join us and live in peace, or pursue your present course and face obliteration.
I'll be compelled to apologize or admit wrongdoing.
First, remember mediation is a voluntary process. No one is compelled to say or do anything they don't choose to do. While people in mediation often offer an apology once they understand the other person's perspective, it isn't expected or required.
It won't do any good. The person is unreasonable and unpleasant.
Generally not true. People are often unreasonable and unpleasant in conflict. However, in an environment facilitated by a professional mediator, the parties tend to behave in a much more constructive manner.
Mediation will just give them more time to complain and verbally attack.
Absolutely not. Professional mediators are trained and responsible for managing a safe process. While parties are free to express their anger and other negative emotions, the mediator will stop any process that is being used to attack.
If I speak freely and honestly, my words will be construed or used against me in a legal proceeding.
The content of a mediation session is treated as confidential by the practicing agency. Each participant signs a confidentiality agreement prior to mediation.
What is my incentive to participate?
Improved relations between the participants will lead to a better solution and better communication and relationships in the long term.
How can conflict be constructive?
It's the only thing that ever is. With the professional mediator in charge of the process, creative ideas are produced, lasting resolutions are made, and people take responsibility for the outcome. What do mediators do? Well, they facilitate meetings, helping to ensure the flow of the conversation. They help people communicate better between each other. They keep track of important issues as they arise. And when the parties are ready, they capture their agreements on paper. There are things which mediators do not do. Mediators do not offer their own opinions. They do not predict the outcomes of any case. They do not assess the merits of any case. And they never pressure parties to do anything. Regardless of what one's profession may be, when acting as a mediator, mediators are neither counselors nor attorneys. They provide a unique service with some legal and some therapeutic elements. There is almost no issue which cannot be mediated. Mediation centers, like the Peacemaker Program, provide mediation in a variety of areas, many of which are free or very low cost. Some common issues which are often mediated are child custody, visitation, and support, issues between parents and children, divorce and separation, small claims disputes, landlord-tenant disputes, neighbor disputes, and work or employment disputes. Check with your local community dispute resolution center to see what help they can offer. We would like to thank you for your time, and we hope you've learned a little bit about alternative dispute resolution. If you have any questions, please feel free to contact your local community dispute resolution center.